So welcome back. I was going to throw it open to the three of you to see if you had any reflections on the course of the day. But there have been such a wealth of issues and questions raised in the chat box that, if I may, I will start with a question which was raised by Neil Patterson. Neil, if you're there, you asked a question about the Church of England's support for the distinction between civil and religious marriages, and that seemed to me to be a question which was of relevance to the contributions we've had from all three of our speakers. So maybe Rebecca could deal with it first, but Neil, do you want to put that question?
Yes, I mean, it's a rather it's a slightly vague one in the sense that this is looking for confirmation of something which in my mind is anecdotage, which is the idea that at previous revisions of the legislation and challenges to it, the Church of England has made representation in defence of the distinction, as it was, say, if you want religion, you have to come to us. But as I say, I'd be interested in who has more specific expert knowledge of how that's happened, or indeed perhaps deny that it has if I'm wrong. But also to comment on that culturally in terms of the way we think about marriage as the Church of England.
So just to sort of pick up on that, I mean, certainly if you look at the debates on the 1994 Act, opening up the possibility of civil marriages on approved premises, that there's no evidence of the Church of England speaking publicly to say that they wanted to ensure that no religious content would be included. And you had quite a few people at that stage saying that they thought religious content should be included, and pointing to the limitations on religious weddings taking place. So there may have been all sorts of representations behind the scenes, but it's not there in Hansard.
Nick, is that something that you've come across in your recent work with the Law Commission? Any sense of support for that distinction?
It's difficult for me to say, I think. I mean, we have had very constructive engagement with the Church of England and Church in Wales, which has been very valuable in putting forward our proposals and in helping to formulate them. I think we are in a position, and this perhaps reflects the limitations of what we can do as a law reform body. We are in a position where, as lawyers, we can look at situations and provide a sort of rational legal answer, which may not reflect pastoral or other concerns held not just by the Anglican Church, and indeed not just by religions, but by non-religious belief organisations as well, who are necessarily putting forward their sort of particular perception of what marriage is and the circumstances in which a wedding should be able to take place. And I suppose to some extent it is our job to try and step back from that and come up with a scheme that is going to work for all of those who are able to conduct weddings. So I suppose we inevitably hear in a consultation from people who are putting forward their particular views, and that the Anglican Church is no different in that respect, and nor should it be. And it's our job to look at where consensus can be found.
Thanks, Nick. Russell, I don't know if you felt you had anything to contribute to that particular issue.
Well, the only thing I would add is that I think the term marriage, and indeed the term wedding, are terms that are not simply legal terms, and they are loaded with quite a lot of different cultural and indeed religious significance. And I think this is a major issue, but also shouldn't be an obstacle to the kind of reform that the Law Commission is talking about here. And the point I'd make is that other jurisdictions have done it, albeit jurisdictions without an established church, then there should be nothing stopping us.
Thank you. Bishop Christopher has posted a question some while ago now, which is directed to the whole panel, if I could ask him to ask his question, and then to give him fair warning, Gavin Foster has also raised a question. So Gavin, I'll ask you afterwards.
Thank you, Ruth. My question really is, supposing the Church of England does move from a location-based system to an officiant-based system, without necessarily tying Church of England marriage to parish churches, would that not imply that we need to have much greater scrutiny and training for clergy who would have, for example, permission to marry within the Church of England? At the moment, that's governed because incumbents are supposed to know all about marriage, how to do it, and all the legalities. Most of them do, but occasionally some don't, in my experience. And then, of course, incumbents train curates, either in the right way to do things, or sometimes, I'm afraid, not in the right way. So I'm really arguing that if we did go down an officiant-based system for the Church of England, with freedom for priests of the Church of England to say marry not just in a parish church, we would jolly well need, comment please from the panel, scrutiny and training in which registries and indeed the Ecclesiastical Law Society might have an important part to play. Thanks,
Christopher. That sounds like a question for Nick first and foremost.
Thank you.
Bad luck.
In some respects, the short answer is yes, in that our scheme, in recognition of the fact that Anglican clergy would be in a unique position of being able to officiate at weddings by virtue of their ordination. And I said earlier, the exact category of that as being a matter for the Church of England to decide, and that GRO would not have a role in the regulation of Anglican clergy because of that status, then the responsibility would fall on the Anglican Church to provide it. But as you said, Bishop Christopher, that is something the Anglican Church provides at the moment. So that the task would be to provide that training in a way that reflects the new law rather than the current law. We would hope in some respects that new law would be simpler, and so the risk of mistakes would be less frequent, but also that within that it would be a matter for the Church how much of the flexibility the law permitted that the Church enabled its clergy to take advantage of. So even though the law would permit officiants to conduct weddings wherever the officiant agreed to do so, there would be nothing to prevent the churches from saying, well, in fact, a vicar can only conduct weddings in the particular church or in particular churches.
Thank you.
Thanks, Nick. Rebecca, did you have anything to add to Nick's thoughts?
Yes, I think it's sort of worth remembering perhaps how little is governed by the statute at the moment. So there's no explicit provision in the statute that says, you know, what the Anglican clergyman does. A lot of it is quite inferential. But there was a question earlier about, would a marriage be void if it was officiated by somebody who didn't have permission to officiate? And under the current law, the answer to that is no. Marriage is only void if the parties knowingly and willfully marry in the presence of somebody who is not in holy orders. So the whole concept of permission to officiate works outside the statute at present and is regulated by the canon law rather than by the Marriage Act 1949. So thinking about how these different things intersect is obviously quite a challenge for law reform. You know, what needs to be in the statute and what can be left to the church as a matter of self-regulation.
It's a crucial distinction, which in a room full of ecclesiastical lawyers can sometimes get a little bit lost. Thank you, Rebecca. Russell.
Yeah, I mean, I would completely agree with what Nick and Rebecca have just said. And yeah, I mean, I think, as I said in my talk, for me, the major move forward in the Law Commission's proposals is this new legal status of the officiant, who would have legal responsibility for doing X, Y, and Z. And absolutely, that officiant needs to be trained, and for my money, have regular training. Who provides that is an open question. But, you know, for me, I think this is an area where there should be complete consistency. Any officiant needs to be trained and needs to undergo ongoing training. And, you know, I don't think that interferes harshly with questions of religious autonomy when these people are conducting ceremonies which have an awful effect.
Thank you. I'm going to ask Gavin Foster to ask his question next about the idea of state withdrawal from the formalities of marriage altogether. And after that, again, to give full notice to those dealing with the tech side of things and those asking questions, I'm going to ask Matthew Chinnery to remember what he was talking about, which inspired such lively debate during, I think, Nick's talk earlier this morning about what religious bodies or the definition of sincerely held belief about marriage and what that means in the context of those bodies who might be able to nominate officiants. Okay, so first of all, Gavin.
Thank you. Yes, we spent a lot of time today thinking about how the state should regulate marriages, and we've sort of deliberately parked the question of why the state regulates marriage. And it just occurs to me, if there's less and less of a common understanding about why marriage matters and what it's actually for, have we now reached the stage where it's plausible to argue that the state should not regulate marriage? It should just withdraw from this field altogether and leave it up to individuals to make private arrangements, contracts, whatever they think is suitable?
Russell.
Well, I mean, that's a very, very good question. Aside from whether it would be politically feasible or not, I suppose my answer would go back actually to the history discussion we had earlier. The reason why the state is interested in this fundamentally is that legal rights and duties come from marital status. And so the state needs to know who is married. That therefore means there needs to be some form of regulation. Now, how hands-on or hands-off that regulation is something which should be subject to debate, and where the regulation is. And I don't want to talk for Rebecca or for Nick, but for me, the Law Commission's proposals take the view that they shift where the state's regulation occurs, from questions about the type of ceremony to the question of preliminaries. And for me, you know, that's the heart of what they're proposing in terms of the Law Commission. But I'll leave them to talk about that rather than me fanboying about it.
A little bit of fanboying goes a long way. Go on, Nick.
I don't think I've ever been fanboyed before, I must admit. So thank you, Russell. But Russell's right in what he says, and that it is a deliberate shift in our provisional proposals to protect the state's interest at the preliminary stage, and in doing so provide couples with much greater freedom as to the ceremony itself. And as Russell said, there are reasons why the state needs to know that somebody is married, because there are legal rights that are attached to the status of being married. There are also other reasons why the state needs to be involved, for example, in ensuring that the marriage is a lawful one, that the parties have capacity, that the parties aren't within the prohibited degrees, etc. So there is a need for state involvement, but we have sort of front-loaded that at the preliminary stage to give greater freedom elsewhere.
Thanks, Nick. Rebecca.
Or to quote Baroness Hale in Radmacher and Granatino, marriage still counts for something and long may it continue to do so. I think it's possible to overstate the decline in marriage. It's worth remembering that an estimated 90,000 individuals go overseas each year to get married, obviously not in the last year, which when you have 250,000 marriages a year makes quite a hole in your statistics. I do think that the law needs to regulate marriage, and that simply delegating it to private agreements would not offer sufficient protection to the parties. We've seen all the problems that can arise within religious-only marriages. And even if we delegated the decision as to what a marriage meant to religious groups, I think there would still be problems there. If you look at the leading case on the recognition of Jewish marriages, for example, before the 1836 Act, it's actually a case about non-recognition because the parties hadn't complied with what was required as a matter of Jewish law. So I think there is a case for having clear criteria as to what makes a marriage as a matter of law.
Thank you. We are hard up against the clock and I have strict instructions to stay with our timetable. So Matthew, can I ask you to put your question to the panel just as briefly as you can, in the hope that we can still stick with our time limit?
Thank you. I think it was an extended example of whataboutery in the text comments, but I think various people were hazarding a guess at where the line might be drawn on sincerely held views about marriages. The example I came up with is if I founded a religion with sufficient members who sincerely believed that marriage was a renewable 3-year contract, or at that point you could then swap around and everybody take a different wife for the next 3 years. Whether that would be an acceptable view of marriage if it were sincerely held to afford legal status for those marriages to be entered into, noting of course that there may be some difficulties at the time of legally recognising the divorces, etc. Following that period. And there were a range of other comments from different people as to what may or may not be considered a sincerely held belief about marriage.
Thank you, Matthew. I rather picked you out of a big crowd of discussion there. Rebecca, you just talked about the ongoing value of marriage. Can you help us with this one, please?
So I don't think there's any idea of legislating for time-limited marriages. And even if an individual held that belief, they would not be able to effect a time-limited marriage or any other marriage that was contrary to the law of the land.
Thank you. Russell, have you got any thoughts about Matthew's scenario?
Well, there's two separate points here. The first point is that the proposals would not affect other laws that define marriage and which require marriage to be a certain thing. And so a temporary marriage wouldn't, as Rebecca says, come under that. I think there's another point there, though, as well, which is important, is that it shows the difficulty of defining what would be meant by a belief about marriage for the purpose of using that as a test to determine which organizations, which belief organizations should conduct ceremonies and which ones should not. And my view is that that shouldn't be a test used for that basis, because it's meaningless, risks being meaningless, or risks state officials having to get into questions of doctrine and theology, which are ill-suited. So that would be my answer to that, in terms of the example shows why we shouldn't require religions or non-religious beliefs, systems, organizations, to specify a doctrine on marriage. For me, that's opening up a whole can of worms, which could be deeply, deeply problematic.
Nick, I'm not sure if you have anything to add to what Russell and Rebecca have said there.
Not too much, but when I answered Matthew's question earlier, I suggested my answer may be shorter than his question, and I think somebody in the chat pointed out that it wasn't. So I think all I need to say now is that I agree with what Rebecca has said. I agree with most of what Russell has said, and the challenge for us is to work out how to capture the right idea in the legislation or in our recommendations.
Thank you. Thank you, everybody. Okay, it falls to me just about within time to sign off and just say enormous thanks to everybody. First and foremost, our three fabulous speakers who have spoken with real depth of knowledge and insight into the issue we've been dealing with today, but also to those people who behind the scenes have really pulled this whole event today together. I hope you will all agree that it's been an enormous success. I'm terribly sorry that we haven't got to half the questions that have been raised in the chat box. So yeah, thank you to Russell Dewhurst, to John Ford, to Luke and Anne-Marie, who've been dealing with the tech stuff behind the scene, and of course to Mark Hill, who has been chairing us for today. Thank you. I'm going to keep it brief and sign off. We're within 60 seconds. I hope I'll be forgiven for overrunning to that small amount. Well done. If everyone wants to show their appreciation with their virtual or real hands, I'm sure that appreciation will be well received.